Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Welcome to eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am George Socha. I head up brand awareness at Reveal. On each episode of eDiscovery Leaders Live, I get the chance to chat with luminaries in eDiscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. Our guest this week is John Stoller. John is a Supervising Assistant Public Defender at the Office of the Public Defender, County of Sacramento. John, welcome.
Hi, thank you for having me.
Glad to have you join us. And you are, I think this is episode number 193 or the like. You are the first guest we've had from a public defender's office. Excellent. So I'm going to ask you to enlighten us a bit. But let's start with you giving an introduction about yourself, who you are, what you do, what your work life is like.
Sure. So I'm a supervising assistant public defender. I manage a team of 11 attorneys, 4 paralegals, several support staff, several interns. And my team specializes in pretty much anything post-conviction. We handle all felony murder resentencings in Sacramento County. We handle any type of post-conviction matter related to writs of habeas corpus. We handle resentencings through the CDCR or the courts. We handle expungements. We handle things like the Racial Justice Act, the new law coming on board in California. And then we handle immigration issues for clients of the public defender's office. I've been a public defender now it'll be 10 years in September. Before that, I was a plaintiff side civil rights attorney for about 2 years.
You have then, it sounds like, a very broad mandate in terms of what you need to cover.
Yeah, we have each pool of litigation that my team is in charge of is very different from the other. For instance, when you're dealing with a habeas, especially with new habeas rules that are coming live in California, you're looking at the case in its entirety. You're looking at any type of issue that related in the police reports from 1999. You're looking at issues in the appeals. You're looking at hundreds of thousands of pages, most of which are extremely old because this is, again, all post-conviction work. When you're looking at the felony murder resentencing project, you're reading old trials, which are anywhere between 2,000 to 8,000 pages long. And when you're doing resentencings, pretty much any nature of resentencing on behalf of a person currently incarcerated, you're reviewing every type of document you can get your hands on. An IEP plan from a high school, foster records, CPS records, juvenile court records, and things of that nature.
What then does eDiscovery look like in this world of yours?
Yeah, I think it'd be helpful to think about discovery, in public defenders and district attorneys are always kind of a step behind private practice. It's just how it is. Government's always going to be a little bit slow to adopt the newest tools. When you have a case moving forward in the criminal justice system, so units other than mine, discovery generally just comes straight from the district attorney. Proposition 115 in California unified our courts and changed the way discovery works and basically makes discovery an informal process between the parties. And then a party can move for discovery if they feel they have the right to through a motion in court. So when you're proceeding through the normal criminal process, so to speak, discovery is pretty seamless. You just shoot the DA an email and they send it back. Our DAs have taken to e-discovery platforms pretty recently. And those e-discovery platforms, I think they use e-Defender through the police agency. They use Axon here and there. But basically, they're adopting these different tools to get the discovery over to us. And it's still rather rudimentary. It's mostly hosting it on file share websites so we can access it. On the post-conviction side, our rights to discovery are less clear. If we want discovery, we usually just have to kind of beg the DA for it and hope they give it back to us. And then our remedies for discovery are also still less than clear. A lot of what I do is new law. Defendants in habeas position have different rights than defendants in the criminal system. So ultimately, though, when we do get the discovery, it's that similar kind of host it on the website and just download it.
What sort of materials then do you get from the?
Yeah, and again, I think it's important to separate out post-conviction versus new trials. New trials, trying a case today is very different than trying a criminal case 7 years. With the proliferation of cell phones and surveillance videos and ring cameras, most crimes we defend are recorded in some capacity, and so that opens up the whole field of metadata and any type of technological data that we need to assess, which then triggers a whole bunch of interviews. Did you really record this thing? What happened before you started pressing play? Because the narrative of how you do trial work has changed due to technology. People get anchored into the video, and so then you need to convince them what happened outside the video is as equally or more important. So in some sense, e-discovery is about, reviewing these, technological pieces we get and then trying to create the story out of them. And to that end, a lot of it is video. It's sitting and watching a lot of body cam. It's reviewing a lot of transcripts of body cams, transcripts of videos. And also pretty much every contact investigating officers have with the defendant is recorded nowadays. So as before, maybe 10 years ago, the only recorded part was the defendant's confession. Now all 8 hours are there and you got to sit and watch all of it.
It's a wealth of new information. It's got to be a challenge to figure out how to get through that information with the time and resources available to you. How do you handle that?
I mean, that is the challenge for every public defender in California right now. Most public defenders, there's typically fewer public defenders than district attorneys. Sacramento, for instance, we have about 120 public defenders. I think we have more than 200 DAs, I think close to 300 DAs, but we handle about 80% of the criminal caseload in our county. So we make use of whatever tools we can. We have contracts with different providers for transcription software, for translation software. We are trying to make use of AI. We are still experimenting with that. We, in fact, just started with Reveal because I want to use Reveal to assess, clients' records for things like harassment and behavior and things like that, and use the pre-existing models that way. So a lot of it is just cobbling it together. But then a lot of it just comes down to doing things a very old school way of sit down, watch the tape, maybe press fast forward at different parts.
With the way that discovery is exchanged in your context, are there increased issues when it comes to things like chain of custody, or is that a simpler setup than in civil litigation?
It is simpler in civil litigation, and this is personal opinion, not speaking for the office. Criminal practitioners get a pass on the pomp and circumstance of evidentiary rules. A lot of times you're dealing with something where a judge is willing to say, in my opinion, this is close enough. This is probably the thing, whatever it might be, right? This is probably the video. So I have personally found, having left, federal civil rights practice and then coming here, when I did, it was a bit of the Wild West because judges were just letting people do whatever they want, admit whatever they want into evidence. And some of that deals with California law. Proposition 8 modified California's constitution to state that all relevant evidence shall be admitted. So maybe they're following that dictate. I don't know. But things like foundation, hearsay, double hearsay, even expert evidence like video recreation, which happens a lot in our homicide cases, statistical analysis, all of that, in my opinion, gets a less discerning test for admissibility than its civil counterpart.
What are the what are the implications, the ramifications of that different test?
Convicting the innocent is the ramifications. When President Obama was in the White House, he ordered the FBI to complete the PCAST report, which I think a lot of your viewers have probably read or heard or reviewed in some manner. And the PCAST report went through various shoddy pieces of criminal evidence done by the FBI and found a lot of them were severely lacking. Fingerprints were found to be lacking in the way that people used to do them. What we call tool marking, whether it's on footprints or bite marks, or were also found lacking for scientific veracity. Bullet matching was wrong. And basically the PCAST presidential report on this issue found that a lot of our forensic sciences that do get admitted every day in criminal court kind of shouldn't pass Dauber or in California Sargon.
With the data you are and aren't getting in civil litigation, there is a lot of email. There's a growing volume of chat messages and other short message formats. A lot of office files, word processing files, and the like, PDFs. Sounds like you've got a lot of video. Do you have the types of things that are more common in civil litigation, or is that less common with what you do?
Well, I mean, it's less common unless we're dealing with what we like to call paper cases. So I had a real estate fraud case a few years ago, and that looked a lot more like, a civil case for fraud and things like that. But for the most part, it's just the nature of the clients. Your average case involving a lot of messages is going to be a drug sales case. And all those messages are going to be on the phone. So that discovery comes to us through a phone dump that then gets processed by Celebrite. They then send the Celebrite viewer over to us. We review it. We have to click through it. And we don't gain training on it. We just have to really try to figure it out ourselves. But that's also another example of how decentralized e-discovery is in this field. If there's all these little different providers that you got to become an expert in to get that critical metadata. I remember I was doing one case, and the linchpin of the case turned out to be this photo that was in the deleted photos folder that proved where he was at the time and space, like movie type of stuff, right? It's well, he could have been there because he took this video according to this photo, according to the metadata. And just things public defenders don't traditionally have the training to do. I just happened to dive into this folder on the Celebrite viewer and found it, and was just very lucky.
Once you get something like that, how difficult is it or easy is it to move that through the processes you need to work with and through the life cycle of the dispute?
Yeah, I mean, for us, in criminal litigation, there's fewer inflection points than civil litigation. With a felony, your standard periods to really settle your case is going to be when the case first starts, then the preliminary hearing, and then when you're assigned out to trial. So the things that exist in civil litigation, such as, that critical deposition, that critical motion for summary judgment that give you that opportunity for, resolving the dispute or like disputing about whether or not it comes in, don't happen. In criminal litigation, none of the pretrial motions are binding on the trial court except for certain motions to suppress. So you could, no one really litigates their issues before they actually get to the trial court. And then once you're in the trial court, you have a day to figure out what you're doing with something with an adverse ruling.
So it's more like civil litigation, say 1975.
Sure. Yeah. Yeah. It's a good idea. Yeah.
Yeah. That must mean as well that there are far fewer discovery disputes, certainly that make it their way to a judge.
No, I mean, it depends how you work up your case. For me, I work up my case with a lot of detail. I want that email exchange. I'm going to subpoena those person's emails and things like that. Going back to the emails and that conversation, part of our problem is, in some sense, our subpoena power is reduced because we end up encumbered by tons of protective orders. We end up encumbered by all these fights about victims' rights and your inability to get into victims' files, because as opposed to a plaintiff or a defendant, in civil litigation, California Constitution gives victims constitutional rights during criminal proceedings that are very different and entitle them to amount of privacy. So it does get harder to get into their files. But going back to your question, it just depends how you work up your case. You could bring tons of discovery motions. For instance, I was litigating whether or not ShotSpotter, which is a gunshot detection device, was misdeployed in our county. And it is my theory that when it was first deployed, it was only deployed in parts of our county where persons of color predominantly lived. And so I was arguing as a reduction of the expectation of privacy for persons of color based off mere geography. So I filed all these discovery motions. I wanted the patents, I want all these things, and ShotSpotter came in, denied everything. I didn't get anything. And yeah, so there was a lot of discovery litigation. Typically what happens though is your discovery motion is brought in the trial court at that time, but it is because the DA has given you a piece of evidence that morning. So you get assigned out to trial, you think you're going, and they say, John, I got the CD for you. You might want to listen to it. And so you bring your discovery motion, and the judge typically doesn't care. And usually it's like 3 months of jail calls. And somewhere in there, your client confesses to the crime, and they've listened to it, you haven't, and you gotta do something about it.
Right, and you've got presumably very little time to actually listen to that, so that you can't. Sounds to me from the way you're describing that in that scenario, there's no realistic way for you to quickly get through that content and find what you need in that.
Yeah, and I don't know if this is below standard of care. If it is, I hope the bar's not listening, but the best I can do is go to the client and say, we have 8 hours before trial, 12 hours before trial. There are 30 hours of calls. I cannot listen to this. You need to tell me if there's anything important. If there is, and it blows up the case, I need to know now, and I need to go get you a better deal. That is generally how we end up working through that problem.
So in an ideal world, in this unideal world, within a smaller ideal world within it, you would get that file. You would be able to load that into a computer system, get it processed so rapidly that then you would be able to run a series of models against it to look for the specific things you cared about most, have it prioritize that content, push it to the top so that you could look at that within minutes. That would be an ideal world within that far from ideal world, right?
Exactly. Like that, that is what we need. Just get through this discovery, get through calls like this, get through, the Star Trek world in my mind. I put in a bunch of cop body cam. It just pulls up the point where the officer says something he shouldn't be saying, right? It's like, oh, There you go.
Yeah, well, you sit on the star deck and say, make it so.
Right, exactly.
Right, yeah. And as much as I'd like to be able to say that our tools will get you there tomorrow, I don't think any tools are quite to the point of delivering that type of functionality in that time frame.
Right.
So when that happens, I gather you're really without options. Sounds like you don't have the ability to say to anybody, look, we just got this stuff. There's no possible time to get through it. We need a reprieve so that we can go through the content and then come back to where we were.
Well, and then that's the Damoclean sword, right? The judge will give you a continuance when you're in that circumstance. I don't want to make it sound like the judges are being unfair. They'll say, I'll happily give you a continuance. But the client's in custody.
Right. And then you've got the continuance, then the clock runs longer.
Clock goes longer. And now you've waived his statutory right to a speedy trial, which then triggers all these rules that allow the opposing party to continue the trial out even longer. And so the client's in that position of, well, I've come this far. I've said no to all these deals. There's my jury right there.
Yep. I can get this done with. And yeah. What short of magic on the software side, what could be done to ameliorate that situation?
I mean, the old school answer is always staffing, just more staffing. Why more attorneys to the case, more interns, more paralegals. But, this is not like civil litigation where a firm can grow as much as a clientele is willing to pay. We can only grow as much as the board of supervisors is willing to fund us. And that's limited by tax dollars and limited by state revenue. So being in this world is you're not in charge of your workload in quite the same way. One, you don't pick the clients come to you. We're the office of first appointment. There's the immense pressure because we care about all of our clients. We got into this work for a reason, so we want to do a good job. And then there's the fact that, multiple different higher up guys above you can take away your money. For instance, I also operate a grant within my unit. I have it was $6 million grant to operate post-conviction proceedings that the state ordered us to do. And I hired 8 people with this money. And they reduced the third year. The governor reduced the third year. And now they're talking about eliminating the third year. And, so that's my staff's lives, but that's also the clients. It's a lot of people get affected in a way that in a civil firm doesn't get affected unless someone really screws the books.
So the major challenges you are up against. Are there changes in the rules with respect to discovery or other things that are either improving circumstances or making them more challenging for you?
Yeah, I think what the criminal justice partners need to do, in my opinion, is for the jurisdiction, everyone sit down together and just choose the platform you're using and get all the offices to buy into the procedure. Because what is happening right now across, at least in my jurisdiction, is the courts want to do one thing. They want to use one platform. The sheriff wants to use another platform. The DA made their own platform they want to use. And we need then, being on the defensive side, we just got to become experts in all of them. And it makes very basic things like file organization extremely difficult. You can't save that file on your Windows Explorer here because it needs to be in the subfolder, in the secure subfolder for the DA's thing over there. And so you end up having to navigate all these hurdles. I do think things are changing. Different agencies are becoming more cooperative with each other. But that is where we need to go. Just choose how we're doing this, choose how to streamline it, and just move forward.
On the civil side, for better or for worse, a very different approach has been taken. Rather than expect that there will be one platform that everyone will use, just not realistic. There have been protocols developed, technical protocols developed to facilitate the ability to exchange information without it getting garbled and messed up and becoming unusable. And they're not perfect by any means. And it doesn't mean that all data from one platform gets to another the way it's supposed to. And it sounds like you've got some additional levels, but maybe what you all need is not so much one platform for all to use. You're probably not going to get that there either. But a set of common protocols that all the platforms are built to work with. Then people can keep their own platforms, but encourage their providers of platforms to conform to the protocols when it comes to the exchange of information. I don't know if that would be a more effective route. I don't know if that would be an achievable route.
I think that's a great idea. I guess when we bring up achievable, our challenges will always be is that judges will always be hesitant to direct the state from how they produce discovery, how they engage in discovery, because ultimately, although we're using the word discovery, from the state's perspective, it's the investigation of crime.
Yeah.
And that's the state's job. That's the executive branch's job, to investigate and prosecute crime. So the judicial branch, I personally think, will always be hesitant of saying, you got to do it this way, and these are your rules, these are your practice, and you got to deliver it this way. And even if we had those rules, I personally think it would be a long time until full adoption. This is a career where, people stick around a long time. They get set in their ways. And unlike civil practice, where you're trying to deliver cost savings to the client all the time, there's little incentive to get the actual worker to adopt these tools. It doesn't change my salary if I use eDiscovery or not.
Right. So there's got to be other incentives, other motivations there. What else is different? If you look at what you were doing on the civil side and you look at what you're doing now, what other key differences are there? I mean, we've just got a couple minutes left, but anything in particular to highlight?
Yeah, I mean, like I've already highlighted that this is the Wild West in discovery. What the plaintiff side wants is coming in. The state will find a way to get it in. The other thing that was very surprisingly different is the lack of access. I almost feel I have less access to discovery than I did as a civil practitioner. Whereas before, if I wanted something, I could get it. Whether it was like setting your trap through your interrogatories, or like you'll eventually get there through deposition and a news subpoena, whatever it was, you were going to get the thing you were looking for. It might be buried, like in the Enron case, might be buried under mountains of emails, but you're going to get it. Here, it's bizarre. You don't get a lot of things. A lot of things that you would think exist. For instance, public defenders have fought Facebook left and right over subpoenas. We frequently do not get responsive information from subpoena. And part of that is going back to that example of, well, all that's good to delay the client's case. So because we are also against the timeline for the client, and the client wants to be done with the case and wants it to move fast, you don't have that opportunity to really stick it to people to force discovery. And when you're not doing that, it then creates a culture of, well, counsel, defense never gets this. Well, yeah, we never get it because we never bother to litigate for it because the client's been offered a 1-year deal and now he wants out of jail, right?
Hey,
Like
you've got
that's
a vicious cycle going on there.
exactly.
Yeah.
So that was very interesting to see of just the competing interests have caused us to, I don't want to say give up a lot of fights, but not come to the ring, not come to the arena.
Yeah, because time and resources don't permit
Right.
that, and the constraints you work in. Well, John, this has been for me very illuminating. A world I didn't know much about at all, and one that I know a bit more about. Certainly, it helps me in particular to better appreciate some of the challenges you face as I go back to figure out what we might be able to do to help you, and as hopefully some of our listeners do as well. So thank you very much for joining us today. John Stoller is a supervising assistant public defender at the Office of the Public Defender, County of Sacramento. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. John, thanks so much for joining us today.
Thank you.